that name to the Assembly on 27th of July.
That is very true.
I have no further questions.
That is true.
I don't know what position Mr. Kokebe will take. I would prefer that you wait until you cross-examine this.
Thank you, my Lord. Followed King.
Yes.
My Lord, I am an officer of the court, and the first is to aid the court and my colleagues. I stand in a very precarious position because the person standing there is the head of government.
If you don't wish to
So,
cross-examine, it's okay.
in this case, the only thing I wish to confirm is that the governor will be confirming the content of his further affidavit, the 28th of July. That's the only thing I'm directing the governor to do, to the extent that he has this far sent a name for consideration of the Assembly. Governor, please confirm that you've since sent a name to the Assembly for consideration.
I'd like to comply to confirm that, and as I do that, to affirm that the initiation of the process indeed started within the 60 days, and that's why I was explaining the process under Section 44, which requires the selection panel, which I had to constitute and to replace certain members of that panel. It is unfortunate and regrettable that that process has taken long, but we have since fully complied with the for us to have that position substantively filled, and I hope that it can be expedited. But for the first 60 days, yes. Once you do that and advertise, there are also provisions on how long that the advertisement is out there, and any questions from the public. And I believe, to the best of my knowledge, that has fully been complied with, Your Honor. So, in as much as we would have wanted it to be done within strictly 90 days, we are sorry that that has not been able to be done within 90 days. The intention is to fill that position. It is in the best interest of the proper running of the administration. But there's not been any vacuum per se, because we've had a fully vetted chief officer serving in an acting capacity. As of now, the ball is in the court of the Assembly to expedite their proceedings for us to have the vetting and approval. I cannot determine if they will pass the name I sent, but of course I can try and persuade them. But it is the constitutional mandate to exercise their oversight in that process, Your Honor.
Thank you, Governor, and it is equally your assertion this far that as a law-abiding citizen, the person you've been since the very beginning, that you have fairly tried to comply with the directions of the court.
Yes.
Directed.
To the best of my ability, in realization of many moving parts beyond my control, I have done my best to ensure that is complied with.
And further, to show your goodwill in compliance with this, that you actually presented yourself to the authority of the court, yes, to communicate your compliance.
Yes, every Kenyan must subscribe to the authority of our judicial system, which is why I have at any point hesitated to be presently available. I was online this morning, Your Honor, so I'm seeing you for the second time, but I'm informed I should have switched on my video so that it comes up, but I was also on the online session at 9 a.m. And I think it's the rule of law is what runs this country and is what keeps us together.
Fair enough, Lord. What I've not asked, I'll leave it and reserve it for submissions. Thank you, Governor.
Thank you very much.
Dr. Akumali.
Yes,
Yes,
Go ahead.
To re-examine the witness.
Yes, please confirm that upon coming to the knowledge of the judgment, you took all the measures that were necessary and expedient to ensure compliance.
Yes, as soon as I was made aware of the judgment and the proceedings that had preceded the judgment, I directed the county Tony to give advice on how best to execute it, which I received, and further to that, that was internally. I did everything that is required of me.
Is this process of appointment one that you can complete alone through the office of the governor without the input of any other player?
Fortunately not. It's not even unfortunate. It's fortunate that it is not, because we have a system of checks and balance in our constitution. But there are different players who must be involved, starting with the selection panel that is empaneled of citizens of the Republic of Kenya, and they have to have their processes. Following that, I have to apply my mind to the recommendations. There's also the members of the public who are involved at that process, who can give their views. That is subject to Article 10 of the Constitution, public participation. Further to that, the provisions of the County Government Act that requires that then that is submitted to the Assembly, that then sets up a vetting committee. It's a standing committee. They are now being reconstituted in the Assembly of Nairobi, which also goes back to public participation, and then finally report to be brought to the plenary for all 124 members of the County Assembly of Nairobi to vote on. So yes, it is not a process that from end to end is resolved by my office.
It's your evidence that once the recruitment process has been finalized by the selection panel, you forward a nominee to the county assembly.
Yes.
Are you in control of what happens in the county assembly?
No, I'm not. But even once, just for context, if you allow, Your Honor, once the panel gives you a list of names, it is not an automatic process just to forward one. You have to also apply your mind to the different, considerations within the county government and the city, and so that also will take a little bit of time. But once I have forwarded, as I did to the Speaker of the County Assembly, then the ball then is, as they say, not in my hands; it's in their court. For them to follow their processes and their standing orders, and then the County Government Act positions are filled in acting capacity, and for how long. That is also provisions within the laws of our land. Not just the County Government Act, but also laws relating to public service management that we have, and we've complied with that as well.
That's all I want. Focus on the nation.
Okay, thank you very much, Governor of Nairobi, for coming to court. There will be submissions by the advocates, and I would urge you to take your seats. Yes, the second alleged consumer, please take the stand. The name is?
Godfrey Akumali. Godfrey Akumali.
Please, Disulu. Please spell for me the second name.
A-K-U-M-A-L-I.
Yes, go ahead.
Thank you, Mr. Tamini. I, when you state your name,
I, Godfrey Akumali,
do swear by the Almighty God
do swear by the Almighty God
that the evidence I shall give before this court,
that the evidence that I shall give before this court,
touching the matter in question,
touching the matter in question,
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you.
Yes, please state your name.
My name is Godfrey Akumali.
What do you do?
I'm an employee of the the city, Nairobi City County, where I serve as the Chief Officer and Acting County Secretary and Head of County Public Service.
Are you aware of the judgment of the court?
Yes, I'm aware of the judgment issued on the 5th of December 2025.
What did the judgment say? To the best of your knowledge?
To the best of my knowledge, the court directed that the Nairobi City County governor was directed to appoint a substantive county secretary within 60 days of the judgment.
Was that complied with?
The process has been ongoing, and to the best of my knowledge, it's now at an advanced stage to completely being complied with.
Okay, Dr. Wisu will ask you questions.
Thank you, Lordship. Morning, Mr. Akumali.
Morning. Good afternoon.
Good. Oh, yes, it's might be afternoon. Good afternoon. Just a few quick questions, just to clarify certain things. What position do you currently hold in the Assembly at the county government?
I'm the acting county secretary and head of county public service. I'm acting there, and I'm also the chief officer in charge of housing.
So you're the acting county secretary. When were you appointed to that position of acting county secretary?
I was appointed on the 7th of August 2024.
So so you're still currently in that position, right?
You said, when did you start acting?
On the 7th of August 2024.
And you currently still serve as acting county secretary?
Yes, I do.
That is, you've been in that position for well over 23 months, right?
Yes, yes.
Very well. In that period, since August 2024, I'm guessing you haven't been serving the people of Nairobi County on a voluntary basis. You've been paid salaries and allowances in the position you hold, right?
For the first 6 months of the appointment, as the law dictates, I was paid an acting allowance. But after that, my salary reverted to that of a chief officer.
So you were saying that for the past 19 months, you have been serving the people of Nairobi County on a voluntary basis, without any allowances whatsoever?
In my contract, it has a line, the last line says, any other duty assigned by the appointing authority.
The question is,
Meaning, I'm just...
hold on. The question is, in the 19 months up to today, are you saying that you have not been paid any allowances
In
relation to the position of acting county secretary?
Yes, I can affirm that.
And remember, you're under oath.
Yes, yes.
Very well. I don't suppose I have anything more. I said this would be brief. I keep my mouth.
Thank you.
No, not be taking my land. My colleague, Godfrey, have any questions?
Yes, Dr. Kamolo.
Yes, my lord. Now, Mr. Akumali, please confirm that you are within the employment of the Nairobi City County Government
I do affirm.
and you have been working there for a reasonable duration of time.
I do affirm.
So what are your duties generally as per your appointment letter?
I'm an accounting officer for the Nairobi City County. I head operations within the department that I'm appointed to, and as such, lead other activities, operational activities within the department and within the sector that I'm appointed to. And lastly, I may be assigned any other duty by my appointing authority.
So in the event you are assigned duties by your appointing authority, is there a possibility that you would fail to discharge the responsibilities assigned?
There is no such an opportunity, since my contract, which I've signed and assented to willingly, has that clause that when I'm assigned such duties, I'll do them.
You have been undertaking service to the county reluctantly or dedicatedly?
Dedicated.
Is your main drive the amount you take home?
No, my main drive is service to the people of Nairobi, so that we can implement the manifesto of His Excellency the Governor, as he stated and promised the people of Nairobi when they gave him this mandate.
Would you insist on getting paid for each and every act of goodwill you perform within the context of your service under the county government?
That would be irrational, and it's not something I'm willing to take. As a Kenyan citizen and a citizen of Nairobi, I'm duty bound to serve the people.
My lord, that's all for consideration.
Thank you very much, Mr. Akumali, for that. That is that for now. Please take your seats so that the advocates can make their submissions. How much time will you take, Dr. Wilson?
Not more than 15 minutes, probably even less.
10 minutes for you, Dr. Wilson?
I can do it 10.
Councillor. Mr. Bukele, how much time will you take?
My lord, at the most of 7. I think that I'm combining both, my lord.
Okay. And you, Dr. Kamolo?
I can take at the same time as the petitioner.
Dr. Wilson, you have 10 minutes.
Very well, thank you, Your Lordship. And let me start by, I'll make submissions with respect to both applications.
Correct.
Try to condense it in 10 minutes, since it's a pretty straightforward matter. Your Lordship, the ingredients of a contempt application are pretty well settled in our jurisdiction. And they can be condensed into 3. And our submission is that all those ingredients have been fulfilled in this particular case. First is that the terms of the judgment or the order of the court are clear, unambiguous, and precise. Your Lordship, the judgment of 5th of December 2025 and the orders therein could not have been any clearer. The governor was ordered or directed by the court to commence the competitive recruitment process and to send a nominee, or the name of a nominee, to the assembly within 60 days of that judgment. 60 days from the 5th of December 2025 is, I believe, 5th of February 2026. But even assuming that there was a delay in the publication of the judgment, Your Lordship, from the CTS, the judgment was uploaded on the 5th of January 2026 at 4:07 p.m. to be precise.
You said it was uploaded
On the 5th of January 2026 at 16:07, that is 4 p.m., 4:07 p.m. to be precise. And we accessed it therefore. And I believe counsel for the respondents accessed it. And to note, all counsel for the respondents were present in court when the judgment was delivered. Nonetheless, I took the liberty to serve them with that judgment on the 7th of January 2026, and there's an affidavit of service on record. So the terms of it are clear, as stated. Knowledge is the second ingredient, and Your Lordship will note that our jurisprudence has long shifted, probably shifted long before I was born, from personal service to knowledge of judgment. And if I may refer Your Lordship to a recent decision by the Court of Appeal confirming that very position, that is the case of Joshua Kimeu Kioko and 6 others versus Wenduno Matu Company Limited.
Joshua Kimeu
Kimeu Kioko and 6 others versus Wendano Matu Company Limited and 3 others. That is Civil Appeal number 258 of 2019. The Court of Appeal at Nairobi's judgment of 25th of March 2026, in which the Court of Appeal confirmed that indeed in this jurisdiction knowledge is what is required. Knowledge suffices, and knowledge is determined by certain factors, including the fact that the judgment was delivered in the presence of the counsel for the parties. In this case, we were all present on the 5th of December 2025 when the judgment was delivered. Mr. Kokego was present. Dr. Kamodo's brief was held by Mr. Mboni. Nonetheless, Your Lordship, should anyone, for whatever reason, insist on personal service, that was indeed done. I personally served the governor, as well as his council, and there's an affidavit of service on record. So knowledge is established. The third ingredient, third and final, is establishment of failure to comply, that there has been failure to comply. Your Lordship, the governor confirmed, both in his affidavits of 3rd of April, I believe, 2026, and 28th of July, that he only sent a name to the Assembly on the 27th of July 2026. That is roughly 5 months. 5 months after the deadline that he was given by court. So it is not disputed that the name was not sent within the 60 days that the court had directed. That is not disputed. And Your Lordship, finally, we submit that this failure to comply was willful. And why do we say it was willful? And that there was bad faith in it? Your Lordship, if you look at the governor's affidavits, the two of them, the governor does not acknowledge that he has failed to comply with the strict orders of the court. He seeks to explain it away. That, Your Lordship, is bad faith. Further, we sent reminders out of courtesy to the respondents to comply. Before approaching this court with our contempt application, we sent polite reminders. Not that we had any obligation to do so, but nonetheless we did. And those reminders were met with silence. With respect to Mr. Akumali, he has informed the court under oath that he has served as county secretary, acting county secretary, for about 23 months. Your Lordship will note that Mr. Akumali was a respondent in this petition, the 5th respondent. He has similarly confirmed that he was aware of the court's determination that any person purporting to hold that office in acting capacity for more than 6 months would be doing so unconstitutional. Yet, he continued to hold that position, and he still does, 23 months down the line. Your Lordship, it's our submission that all the elements.
Yes, Mr. Kukibe. Thank you. Order at the rise of this court, the court will be asking itself whether the said elements of my land friend Dr. Wisu has outlined what will be met to warrant the finding of His Excellency the Governor, Johnson, Sakaja, and Godfrey Akumali for contact. That will be a mind-boggling question, definitely. As earlier mentioned, I took an oath that very oath, my Lord, equally ascribed to it at an earlier stage, and subsequently they affirmed the same upon resumption of the bench. My Lord, there comes this court wields both powers to be merciful, equal to the authority of the court. Not only did he submit to the authority of the court, my Lord, he has undertaken and belabored to make my land friend, and these nuances pitch both arms of government at various instances to take certain duties. My Lord, earlier on, Dr. also interjected when the governor attempted to school us on the timelines or the calendar of the assembly. I believe he was rightly placed to do so because he served as a senator before, so he understands how parliament operates. Upon a name being presented, and that name, my Lord, we do confirm has been presented. And to that extent, the 30 days that are in question, that my land friend Dr. Wiso was calling to your attention and screaming at March for that process, that this process ended on or about the 5th or thereabouts of March. Actually, based on his timing, when he actually served, when he brought it to the knowledge, and I believe I loved it when he talked about knowledge, he brought the judgment to the knowledge of both respondents on the 5th of January. That gives us somewhere into the 5th of March. Those becomes the facts. So if you were to look at the 5th of March as the actual sunset clause, or the sunset day in which the assembly or the governor was to act, my Lord. Sadly, to my land friend Dr. Wiso, which I know he does not know because he's more into the international spectrum, he will notice, my Lord, that the assembly went on recess 7 days thereafter. That they dictate, my Lord, that the time ceases to run. The assembly only came back, my Lord, from the recess. His question. We will not contend on the issue of knowledge, neither will we contend on the issue of precision. He did indeed confirm to the court that he knew about it. The only issue that will be is what were the timelines. My Lord, those timelines will still be dictated, which this court cannot replace itself. Neither can the government. But I'm glad, Lord, that as a law-abiding citizen, the demands of Lord, I will be urging my land friend Dr. Wiso that if it were not for anything, he considers at this point even withdrawing his application, so that it doesn't gives the court easy time to the county assembly. We plead with you that when you will be retiring, or when you consider to give us and also assist and aid in respecting not only the rule of law, but equally the authority of
Dr. Kamolo.
Yes, my Lord.
You kept time.
Thank you,
Yes.
My Lord, from the onset, we observed that the petitioners have been done so effectively, given that there was none. there was a failure to comply with Order 9, Rule 9 of the Civil Procedure Rules, to the extent that Messrs. OLC law advocates purported to replace.
Your Lordship, I hesitate to interrupt you. Leak into these proceedings the question of the application which is set for mention in September. The question of OLC law firm and Dulo and accounting advocates. I believe is.
My Lord, there is a notice of change of address which is available, and it was filed, served as a legitimate document to alter representation. So by purporting to dislodge the firm of Dulo and Company Advocates, then the firm of Messrs. OLC Law Advocates, in a manner unknown to the law. What is the cure, my Lord? The cure for such an anomaly, as it may.
So what is your opinion on applicability of the civil procedure rules?
Yes, the civil procedure rules would require, if I was to read it verbatim, of the laws of Kenya, which are applicable to proceedings of a civil nature, to which constitutional petitions fall. So it's applicable. In the question of representation.
Yes.
So there was an non-compliance in that respect. But aspects, we have already been able to demonstrate through the evidence by the first respondent that there has been consistent effort to work. The judgment never became available on the date of delivery, to wit, 5th December 2025, but was uploaded sometimes later, after which time, then those realities must be borne in mind. The knowledge of the order is not disputed at all. The first respondent and the fifth respondent have confirmed that they were aware of the judgment. And besides being aware of that judgment, even previously, it is shown through the documents we have annexed to our reply affidavit, dated the affidavit one on 3rd April 2026, by the first respondent. We have shown that there was continuous engagement between the office of the first respondent and the office of the Honorable Speaker of the County Assembly of the Nairobi City County Government, Nairobi City County Assembly. Indeed, there was correspondence on Tuesday, 19th August 2025. That is way before the determination was made, whereby the first respondent had forwarded a list of names of the selection panel for purposes of appointment of the county secretary. There was feedback from the office of the speaker on the same subject on 2nd December 2025. and still there was further correspondence on 11th December 2025. This points to the fact that there has been no willful disobedience to the orders, but indeed there has been proactive effort on the part of the first respondent to ensure that the vacant office is duly filled. The order that was issued on 5th December 2025, that is order labeled D, it was an order of mandamus comparing the first respondent to within 60 days initiate a competitive recruitment process. So categorically, it was not to appoint because the Honorable Court appreciated the fact that the process was too tired. It involved the action on the part of the executive and action on the part of the assembly. So what the first respondent needed to do was to initiate, and it is in black and white, which we have already confirmed that the first respondent did, notwithstanding the multiple hiccups that are prone to such a process, given that it involves several areas of action. With regard to the fifth respondent, who was also a party to these proceedings, the declaration, no specific order was directed towards the fifth respondent. The order that would be pertinent in the circumstances is order number C, which was a declaration that payment of acting allowances to any person acting as county secretary beyond the 6 months statutory limit should not be paid. So the question was about the non-payment of the benefits that would be associated with acting in that role. Otherwise, my lord, there was no specific order that was directed to the fifth respondent, notwithstanding the fact that he was a party, because he was duly named as a party in the proceedings. So there has been no bad faith as purported by the petitioners in terms of seeking to have the office properly occupied by a substantive holder. Now, the law governing the contempt has more ingredients than the ones cited by Dr. Owiso for the petitioners, because once the Contempt of Court Act was declared unconstitutional, the law that now serves is the Judicature Act, read together with the English law on contempt, the English Civil Procedure rules as amended in 2020, and it has set out a raft of requirements at Part 81, most of which have not been complied with by the petitioners. At Part 81.4, which deals with, provides around, because they are numbered from A, the requirements are numbered from grade A to grade Grade S, the requirements. So the a person seeking to prove content must, for instance, show that a penal notice was added to the front of any order allegedly breached. To the court. They cannot do so while in breach. The alleged contemners under Article 27 of the Constitution are entitled to equality before the law, equal benefit of the law, such that a party who seeks to have action taken against another party must equally comply with all the applicable laws. No one can seek to enforce the law while in breach. For all those reasons and all the reasons that we have articulated in our affidavits, notably the affidavit shown on that of April 2026, and the further Brian affidavit shown on on 28th of July 2026. So on the basis of those documents, then we shall seek that the application for contempt be dismissed with costs to the 1st and 5th